All right. Welcome back. Welcome back. We have a fun one today, I hope. And I'm going to give people a little time to get on here. And it just populated that there are some people on here. All right. So today, basically, we're going to start. We have a few brief updates in the Janet debacle, the Braun versus Day. And then we also have a brief update in Decastro versus LVMPD, neither of which, frankly, were worth a video, but they're worth mentioning here. But before I do that, I should say hello. Good to see you, Ambroise. I'm terrible with French, so I apologize. And Kuma King, I haven't done a ton of lives, so for most people, it's a good chance it is their first time live, but I'm glad to have you here. I, uh, as I said last time, I enjoy doing lives. It's just by the time I get around to them, it's usually midnight and easier to just record. So, yeah, but Linz, good to see you as well. Those berries in your profile picture always look appetizing. I always say if I get rich, I'm moving to Hawaii and I'm going to have 2/3 of my diet fresh fruit, straight from the tree, vine, whatever, and just fresh and delicious. And yeah, Empty Woods, good to see you as well, and you, JT Davis, and Bad Scooter. So for those of you who are new, I should introduce myself now that I've said hi to people. For those of you who are new, I'm Joe. I'm an attorney licensed in the state of Utah. Today, we're talking about two neighbors of the state of Utah, where the main course is going to be in Idaho. We're also going to Nevada briefly and Illinois briefly. And open mic, thank you. So basically, going to Nevada, like I said, scroll up. Decastro versus LVMPD. This, like I said, this wasn't worth a whole video all on its own, maybe a short, but I don't understand this. I don't understand it. And that's a good reminder from Bad Scooter. This is not a petting zoo. It's an animal safari. Keep your arms and legs inside the car at all times. Don't contact any of the people we talk about. Although, at least in the case of Braun versus Day, do go watch the girlies. They're all excellent and deserve your support. And, they've got their GoFundMe. Watch their videos and like and subscribe. But don't contact Janet, don't contact Lauren the Mortician, don't contact Delete Laws, don't contact Ashley Giard. So yeah, good reminder. Thank you. But yeah, so as I said, I don't understand. Delete Laws on January 10th, we got a notice of appearance by attorney Michael Mee on behalf of Delete Laws, which doesn't make sense. And so he's been retained. The extension of time for his response to the motion to dismiss is due on the 26th of January. So 2 weeks from today, 16 days from the time Michael Mee made his appearance. So, if I make an appearance the day before something is due, you bet I'm filing a request for a continuance because, they just hired me. I don't have time to do anything overnight. But 16 days, that's plenty. Especially Michael Mee is his attorney on the criminal case. And so he knows the facts, which is what makes this so confusing. Number one, delete laws. He uses his pro se status as a superpower. At least he thinks it's a superpower. He tries to bleed the defendants dry in attorney's fees. Well, he's not paying any himself, but presumably now he is, unless Michael Mee has some sort of contingency agreement, or it's ostensibly a civil rights case. And so if you win a 1983 claim, there's a really, really good chance, like almost guaranteed, that you're going to get your attorney fees paid by statute. So lots of times what attorneys will do in these cases is they don't do it as a contingency agreement. They basically have a fee waiver, is the best way to describe it. So they bill hourly, and if they lose, they just waive the fees. But this case is such a stinker that it calls into question, does Michael Mee not understand how bad this is, how bad a case this is? Because there isn't going to be a payout. He's not going to get paid. And maybe Delete Laws hired him now thinking, hey, we've got him by the short and curlies, and this is the time to hire an attorney to negotiate a payout for me. But there's a motion to dismiss outstanding. That this is his weakest position. It's until and unless he survives the motion to dismiss with at least some claims, he has no leverage. But it could also be that, as we discussed last time when we looked at the motion to dismiss and it wasn't the motion to dismiss, it was the motion to strike, or in the alternative, extension of time to file. Delete Laws showed that even though he brought that motion in the alternative, he doesn't understand pleading in the alternative, because he didn't understand. He has to treat that as both a motion to dismiss and a motion for summary judgment. He needed clarification because he didn't know how to proceed. So that might be why he brought on an attorney. But as I said, if I'm Michael Mee, unless I'm getting paid, I'm not signing up for this stinker of a case. And frankly, I wouldn't anyway, because what let's just say your captain for the White Star Lines, the Titanic has already hit the iceberg. Are you going to fly in on helicopter and say, hey, I'm here to captain this sinking ship now that it's hit the iceberg? No, you're going to steer well clear of it. And I don't want my name attached to this. I don't know why Michael Mee does. But then, just looking at it, it's real short. Comes now, Michael Mee, Esquire, on behalf of plaintiff Jose Decastro, who provides his notice of appearance as retained counsel on behalf of the plaintiff and asks that all future service be provided to counsel at the contact information set forth herein or through electronic service. Dated this 10th day of January 2024, Michael Mee, Esquire. Now, that gives us a little clue. Now, I have never used Esquire on anything but business cards. Lawyers, basically, we can use it. It signifies we're lawyers. But if I'm filing paperwork, if I'm filing a motion, if I'm filing an appearance, I don't have to signify through Esquire. I'm a lawyer. I'd have my bar number right there, just like Michael Mee does. I'd have my bar number in the caption, just like Michael Mee does. That shows I'm a lawyer. The Esquire, it doesn't signify you're a lawyer in this context. It signifies that you're a dill hole. Lawyers don't use Esquire for anything but their business cards. You know, maybe sending a bill dispute to Comcast. You know, it's just, you don't do it. It makes you look like a dill hole. So that's where we are on delete laws. So presumably we won't see any updates until the 26th. And I look forward to seeing what Mr. Mee has to say, because frankly, I think it's not going to be very good. But, you know, he doesn't have much to work with anyway, so it wouldn't be good for that reason too. So next up, we have just a real brief update in Braun versus Day. Like I said, this isn't worth a video all on its own, but summonses have been issued to the girlies. They have apparently been served. There's nothing on Pacer showing that they've been served other than the docket entries showing summonses have been issued on January 8th for Becca Day and the Do We Know Them girlies, and then on January 10th for Caffeinated Kitty. So the I believe they've retained an attorney together to represent all four of them. So basically 21 days from January 8th, so January 29th, and that's basically when we can probably expect either a slap special motion to strike or a motion to dismiss or whatever. And basically that's when I'll be expecting something substantive. They'll, you know, in the meantime, we'll get the appearance of counsel and stuff. So that's basically where we are with that. And so, yes, it is common for lawyers to do criminal and civil. Like the criminal defense firm I was at for a while, they did that and plaintiff side employment law, just because the boss, the owner, was sued by a former employee. It was a frivolous suit, and he defended himself, and through that he learned employment law. So he's like, hey, I'm going to practice this. And it ended up being a good practice area, because just like with civil rights violations in employment law, generally if the plaintiff wins, they're going to get their fees paid. And you know, you might have been stiffed $1,000 worth of wages. If you take it, you know, if you actually litigate it, you know, if the defendant drags it beyond the basically demand letter, they might spend $20,000 to get a motion to dismiss in, over $1,000 in unpaid wages. And I saw some of those. You know, it was a lot more than $1,000 in unpaid wages, but you know, in the short time I was there were some multi-$100,000 attorney fees that far outweighed the actual damages. So, but for criminal defense, lots of people will do criminal defense and personal injury because both practice areas have you in the courthouse a lot. They have you in trial, and so just as an example, um, look at Lawyer You Know, Tragos Law. Papa Tragos primarily does personal injury, I believe, but he does some criminal defense. Lots of criminal defense lawyers will do civil rights litigation because it's related to the criminal defense area. Oftentimes, the the criminal defendant will have a legitimate civil rights complaint, and so like here in Salt Lake, can't remember the lawyer's name, but he the main rock radio station here in Salt Lake is K Bear 101, and they'd have a weekly session with a guy who primarily talked about DUI defense, but he really pivoted strong into doing civil rights litigation. So yeah, and so Michael Mee is not a public defender. He's a private retained counsel. So yeah, you unless the public defender is a contract counsel, basically, um, some jurisdictions will have the designated public defender office, but some it's just they hire private defense attorneys, and if that were the case, they're generally free to take outside clients. So, and the meat of this stream definitely is about how boned Giard is and how I'm upset that it's got this far, but it is not a conflict because the conflict would be he representing the same client in different cases is generally not going to be the problem. The conflict would be, let's say Michael Mee had been a prosecutor for LVMPD, or well, for Clark County, or he had been retained by LVMPD as Craig Anderson had been. That would be what makes a conflict. Other than a duty of professionalism and fair dealing, Michael Mee doesn't owe any duty really to LVMPD, to Craig Anderson. So any conflict would be harming them. So for his client, there is no conflict. And yeah. So, and definitely Craig Anderson is much more experienced than Michael Mee. Of course, there are people from my class, as I've mentioned, that I would have gladly hired year one. There are people I wouldn't hire now. I wouldn't hire them with 30 years of experience. So I can't comment much on Michael Mee. 2 to 3 years, but from what I've seen, I'm not super impressed. But he serves a function. So, moving on though to the main course, we have Scofield versus Giard. This, for those of you who are new, this is the TikTok psychic being sued by the University of Idaho history professor for defamation because the TikTok psychic did a tarot reading and used the results to accuse the professor of committing the 4 murders at the University of Idaho with no evidence except for her TikTok. She made 100 TikToks about it, over 100. She has not backed down. She still insists, despite admitting she has absolutely no evidence whatsoever. She says, "Yeah, but I can get it in discovery." Except you can't, because Professor Scofield, frankly, is entitled to summary judgment now. She was a month ago, to be honest, but once again, the pro se privilege. So where are we in this? Well, Ashley Guillard did not respond to discovery. She did not respond to the requests for admissions. And so those should have been deemed admitted. And so in October 10th to be exact, Professor Scofield brought her motion for partial summary judgment. Partial because she's asking the court to declare she has won, but then they would still have to have a trial to determine how much she has won. And because Guillard hadn't responded to any discovery request, but in this case, we're specifically focusing on the requests for admissions. No, computer, I do not want you to restart right now. That would be obnoxious. But because she didn't respond to the request for admissions, they should have been deemed admitted. That's the rules. And so Professor Scofield brought a motion for partial summary judgment, which is basically to win a summary judgment motion, you have to show the court there are no questions, there are no disputed facts. So because these facts should be deemed admitted, they're undisputed. But Ashley Guillard said, well, I didn't get them, even though they were emailed to me. So how could I be expected? And besides, I was in New York and couldn't log into my email, apparently, and just nonsensical excuses. But because courts go so easy on pro se litigants, and as we've discussed, they are supposed to construe their pleadings liberally. They can't make up claims out of whole cloth. But if the elements are there, they have to say, yeah, that's good enough. But we've seen there are Supreme Court case law saying, while we construe their pleadings liberally, pro se litigants are held to the same standard as attorneys in matters of the rules. So the federal rules of civil procedure, she should be held to that standard. And reflection, you are right on time for the main course tonight. We just briefly discussed little itsy bitsy things in Decastro versus LVMPD and the Girlies lawsuit, Braun versus Day. But as we have seen over and over again, both here and in Delete Law's many lawsuits, they still go easy on them about the rules, which at this point, especially here, it just pisses me off. To the point that I didn't make a video specifically about it. I just was going to wait and rant at the beginning of this one. So, basically, the court said, you know what, we're going to go easy on Guillard again, and they held a hearing, and basically said, all right, Giard has until December 15th to respond to the request for discovery, the request for admissions, interrogatories, requests for production, all that. Apparently, she responded to the request for production or for the request for admissions, but not for the interrogatories and stuff. So she still is failing at discovery. And the 15th was supposed to be the close of discovery. And so the court set that as the drop dead date for that. And then January 12th, so today, as the deadline for dispositive motions. A motion for summary judgment is a dispositive motion. It would end the case, at least as far as, the responsibility phase. So, Pat's Cats, you're right on time for the main course. I just caught everyone up on where we are in this case. So what we have now is we have the new partial summary judgment and memorandum in support, and the new amended statement of undisputed material facts, and all of these declarations, and we're not going to get into all of that. That would take us hours, and yeah. So basically, I've only taken a glance really at the statement of undisputed facts, and frankly, I expect, even though, the court going easy on Giard does nothing but cost Professor Scofield money in attorney's fees. And I expect this is going to look very, 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 very similar to the previous summary judgment motion we looked at, but just minor changes. So this is the hottest room in the house. Winter has finally come to Utah. It's been snowing all week. It's the ski resorts. Alta could see 100, 150 inches of snow by the end of the weekend, which is good. We need the snow. Everywhere else in the house is a bit cold, but since this room is right next to the boiler and all the hot water goes through the ceiling and the walls here, it's the hottest room. So I had to unzip my fleece. But that is a good question, reflections. You've got it. If the partial summary judgment is granted, it basically would result in the court saying, yes, Professor Scofield, Ashley Giard defamed you, and we need to hold a trial to determine the damages. Because the damages in this case, because it's defamation, are not a known sum. It's not a sum certain, is the language the law uses. And so we need a jury or a finder of fact to determine how much she has been damaged. Excuse me. How much she has been damaged. That shouldn't be drinking ginger ale while doing a stream. But if this were like a breach of contract, you could do a summary judgment, not just a partial summary judgment, because in a breach of contract, because the figure is in the contract, you know how much you've been damaged. Or if Ashley Giard brought the summary judgment motion, well, because her counterclaims were already all dismissed, her summary judgment motion would just be to dismiss it, basically summary judgment in favor of the defendant. And so that wouldn't be a partial summary judgment because she's not asking for damages other than maybe attorney's fees, but she doesn't have an attorney. So she could just ask, find in my favor that I didn't defame Professor Scofield, and dismiss the case. As from what I've seen so far, there is no summary judgment motion from Ashley Gear, because she could have brought one, but the deadline was today, because even from the defendant, a summary judgment motion is a dispositive motion. And as I mentioned, the deadline for dispositive motions is today. Now, there's this new leave to file document. I don't know what that is. So we're not going to bother with it today. Besides which, I think what I already have opened will be a long live stream anyway. At least it will be plenty of a live stream. So with that, let's jump to the documents. And first we have the amended motion for partial summary judgment. As I've said, it annoys me that they split these, the motion and the memorandum in support. That's dumb, but that's what they do in this jurisdiction. So we get two documents. But pursuant to Federal Rule of Civil Procedure 56 and Local Rule 7.1b, Plaintiff Rebecca Scofield again moves this court for partial summary judgment as to liability on each of her claims. And I'm not going to pull up Rule 56 because we looked at that in the last video where we discussed the summary judgment. Just as a refresher, Rule 56 is the rule for summary judgment. So this amended motion for partial summary judgment is supported by the memorandum in support, Professor Scofield's amended statement of undisputed material facts, the amended declaration of Wendy J. Olson with exhibits thereto, the amended declaration of Rebecca Scofield with exhibits thereto, and the pleadings and other documents on file in this action. Dated January 12th, 2024, Stoll Reeves LLP, signed Wendy J. Olson. Now, just as a callback to Michael Me Esquire, let's look at this signature block. Signed Wendy J. Olson, attorney for plaintiff. We didn't need the Esquire. This indicates that, at least based on this, attorney Wendy J. Olson is not a dill hole like Michael Me is. Boy, that just felt dirty coming out of my mouth. Me is, although it was grammatically correct. It felt dirty. It felt grammatically incorrect, but me, M-E-E, is his name, not a personal pronoun. So, and then up here, we have the Idaho State bar numbers, but no Esquires. Because it's obvious to the court by the fact that it says attorney for plaintiff. It's obvious that they're attorneys. The Esquire is just, you know, ugh. But either way, that's not a big deal. It just annoys me. So I don't think she's asked for attorney's fees specifically, but she's asked for Rule 11 sanctions in the amount of $1 million. But even still, she did that in the wrong way because that's not a cause of action. She tried to bring that as a counterclaim, but then she tried to do it in other motions as well, and you've got to bring a sanctions motion. But I mean, delete laws is dumb enough to ask for attorney's fees. And the reality is, like, in filing your answer, in filing your motion to dismiss, asking for attorney's fees while you're pro se, well, it's kind of questionable. But at the same time, it's like, well, you might hire an attorney down the road. And so asking for attorney's fees now isn't terrible, but at the same time, you're not entitled to them. So Rule 11 has several constituent parts. So 11A is about the signature. So, every pleading, written motion, or other paper must be signed by at least one attorney of record in the attorney's name or by the party personally if they're unrepresented. 11B, representations to the court. So by presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or party certifies that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, that one, it's not being presented to her for an improper purpose, that the claims, defenses, or other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law. 3, the factual contentions have evidentiary support, and 4, the denials of factual contentions are warranted on the evidence. So, but then C is sanctions. Rule 11C, sanctions. So the problem is I think delete laws, when he's rattled his sabers about sanctions, well, usually he does it in emails to the attorneys, and so that would be the notice. But with Giard, what she gets wrong is, so in general, if after notice and a reasonable opportunity to respond, the court determines that Rule 11B has been violated, the court may impose an appropriate sanction on any attorney, law firm, or party that violated the rule or is responsible for the violation. And then C2 is the motion for sanctions. C3 is on the court's own initiative. So the court can sua sponte meaning on its own, bring sanctions. 4 is the nature of the sanctions. 5, limitation on monetary sanctions. And so, frankly, Ashley Giard asking for $1 million in Rule 11 sanctions probably is not within the limitations on monetary sanctions. And then 6 is the requirements of an foreign order. And then Rule 11D, the inapplicability to discovery. So the Rule 11 doesn't apply to sanction. It's not a sanction for discovery disputes, because the discovery rules have their own built-in sanctions, such as, if you fail to respond to the request for admissions, they're deemed admitted. That is the sanction. So you don't bring a Rule 11 motion. But as I mentioned, 11C1, you need notice and an opportunity to respond, a reasonable opportunity to respond. And I can't remember what that reasonable opportunity to respond is, whether it's 14 days, 7 days, 21 days. That doesn't matter for today. Either way, basically what that requires is you need to contact the opposing party and say, hey, you have done this thing that is sanctionable, such as you have brought this motion for the improper purpose of causing an unnecessary delay. And I want you to fix that by retracting your motion. You have until this date, and after that, I will file my Rule 11 motion for sanctions. So, but Ashley Giard, she just asks the court for sanctions, no notice, no reasonable opportunity to respond. So, you know, that's a bit of a whoopsie doodle on her part. But either way, and I agree. I believe Ashley Giard has done sanctionable things, like just looking the 11B3. The factual contentions have to have evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Ashley Giard is still making these fanciful claims with no evidentiary support. She has nothing. She even says she has nothing. She's trying to latch on to the well, I'll likely have evidentiary support after a reasonable opportunity for discovery. Except she's pulling that out of her ass. She's making things up. She does not know. She has no good faith basis to say anything. But, oh well. So, moving on, we have the memorandum in support. Exactly, Reflections. She has psychic intuition. I mean, her intuition, I'd agree with the first syllable. She has psycho intuition, but yeah. But the memorandum in support of plaintiff's motion, amended motion for partial summary judgment. And this is a 26-page document in total, but it's really about a 20-page document, and then all the ancillary stuff make up the other 6 pages. But looking at the table of contents, we have the table of authorities, introduction, background, factual and procedural history, legal standards, the arguments, which consist of Ms. Giard's responses to requests for admission do not raise a genuine dispute of material facts. They support an award of summary judgment to Professor Scofield. Because remember, the standard for summary judgment is that there is no genuine dispute of material facts. They're presenting the same thing, or they don't have anything to dispute the fact with. Just saying, yeah, I don't agree with your fact, that doesn't mean it's a disputed fact. You're just saying you don't agree. You've got to bring something to the table to dispute it. Now, you only need to bring enough to dispute one of the factors. You know, this is defamation. There's what, 3 or 4 factors to a defamation claim. It has to be a statement. The statement has to be published. The statement has to be false, and it has to cause damages. Now, Professor Scofield is not a she's not a public persona. She's so the heightened standard doesn't apply to her. Ashley Giard tries to say it does. She's a professor. Hey, that's not the same as being Tom Cruise. But next up, the facts conclusively established by Ms. Giard's admissions, the TikToks she posted, and Professor Scofield's declaration demonstrate Professor Scofield's entitlement to judgment as a matter of law. Judgment as a matter of law is summary judgment. It's also abbreviated as JNOV, which it basically is judgment. Yeah, I can't remember. It's Latin, I think. But either way. But, sorry, the point I was going to make with the 4 factors of defamation, if Giard can bring any fact, any disputed fact that means any one of those elements is not met, Professor Scofield doesn't get summary judgment. So if Ashley Giard has some dispute, something to dispute the fact that it was published, if she can bring evidence, or even if she can bring a court case, let's say a court has ruled, I don't know why they would, but let's just pretend a court has ruled that posting videos on TikTok is not publishing the statement. Then Professor Scofield can't win on summary judgment, because there's not undisputed facts. She'd have to show that it was published some other way. Now, that was obviously a ridiculous hypothetical, but we're dealing with ridiculous facts here, at least on one side. That's it, reflections. And so that's, I'm getting ahead of myself. So that's judgment notwithstanding the verdict. And so that's basically after the JNOV is basically when if the jury has already returned a verdict and you bring the motion to the court saying, Your Honor, there's no way, based on the facts that were presented, the jury could have come to this conclusion. So please disregard it and rule in our favor instead. So that's what the JNOV is. Since it's Latin, I forget. There's so much information to take in during law school that if you don't use something every day, you forget it. That's it. How did I get it? So you can just be minding your own business, walking down the street, and some moron, some dreg of society can decide, I'm going to ruin your life. There's nothing you can do about it. This is going to be all-consuming. You are going to receive death threats. You are going to have to defend yourself based on nonsense. And I mean, that's why we have defamation laws. But unless Ashley Giard has a nest egg we're unaware of, Professor Scofield probably won't actually recover anything from her. So that's why I keep linking, even on videos not related to Professor Scofield, I keep linking her GoFundMe in the description of all my videos, because this is important. Yes, it's just one person, but it is an important case. It is important for her to be able to continue, and without help, it's financially devastating. She's already said in filings she's spent over more than her annual salary. She has spent on lawyer fees, and that's terrible. Yeah, you'd think she'd know. Well, maybe she's psychic. She's just not a self-aware psychic. But yeah, so Professor Scofield is entitled to judgment as a matter of law on count 1. Remember, there's 2 counts of defamation, one for the accusations of murder and the other for accusations of having an affair with one of the murdered victims. So let's just get through the table of contents. We have the table of authorities. So these are the cases they're relying on. They're pretty much all the same as before. Then we have the statutes and the rules of civil procedure they're relying on, the other authorities. So these are persuasive authorities. They're obviously not laws, although some of them, like the restatement of torts, yeah, they're basically academic books, but courts adopt at least certain sections of the restatements of torts and say, yeah, this section applies in this jurisdiction. So it's at least as far as the restatement of torts, they are binding law, most likely in this jurisdiction. But then this what's wrong with sex between professors and students, it's not what you think, in the New York Times. So yeah. So introduction. Plaintiff Rebecca Scofield, Professor Scofield, respectfully requests that the court enter summary judgment on both her claims against defendant Ashley Giard. As a matter of law, Ms. Giard has admitted to defaming Professor Scofield. Ms. Giard's admissions, the TikTok videos she posted online, and Professor Scofield's declaration establish beyond dispute that Ms. Giard is liable for her defamation of Professor Scofield. Accordingly, all that remains is for a jury to determine the extent of Professor Scofield's damages. And delete laws most definitely is the most egregious, at least that we've covered, of drawing out nonsensical cases to cost the opposing party money. Yeah, Paul Berry, exactly. The McCabe family knew someone who was murdered, or at least presumably was murdered, was killed, and Turtle Boy decided, I'm going to latch on to the defendant in the murder case and ruin the McCabe family's life, and various others as well. And of course, Turtle Boy discovered that, you know what, witness intimidation, witness tampering is a crime, and he is going to spend a lot of time in prison for that. And I wouldn't be willing to spend time in prison for someone else. But you do you, Turtle Boy. So background, factual history. In November 2022, 4 students at the University of Idaho were murdered at a home near campus. Ms. Giard, a resident of Texas, took this tragedy as an opportunity to post sensationalist content online to attract clicks and make money. And you'll notice, at least for this bit, the citations. So ECF 1 is the complaint, and then ECF 20, but we'll see as we get into it, we'll see the citations to the statement of facts. So it'll be abbreviated SOF paragraph 30 or whatever. So, according to Ms. Giard, she used her spiritual practice, psychic abilities, and metaphysical tools, including tarot cards, to post over 100 TikTok videos of her supposed findings concerning the murders near the university. I wish she'd use her metaphysical snow shovel to clear my driveway. That would actually be helpful. Ms. Giard's purported findings, which she posted on the social media website TikTok, went like this. Professor Scofield had a same-sex affair with one of the victims and then planned, initiated, ordered, and executed the murder of the 4 University of Idaho students. Ms. Giard has admitted that she made these sensationalist statements, although she now claims she was just relaying the results of a tarot card reading, and she has admitted that these statements were not based on any facts. See generally the statement of undisputed material facts in support of the motion for summary judgment. SOF, paragraphs 11 through 19. So, like I mentioned, we're going to see a lot of citations to the statement of facts. Ms. Guillard has also admitted that her false statements are based on her spiritual research, intuition, and instincts, and that she currently has no written information or oral information from another human being that support her false statements. She states that she hopes to find facts to support her position through discovery in this case. But so far, she has none, even though discovery is closed. Remember, when we looked at the docket, well, no, it didn't say in the docket, but it will say in the statement of facts. But discovery closed on December 15th. So since discovery is closed and has been closed for almost a month, there's no way she's going to discover things through discovery since there is no more discovery. And I should go back up since Paul Berry is here. Thanks for letting me know that this was posted today, Paul. I wasn't paying attention. I knew it was due today, but I didn't know it had already popped up on the docket since Idaho frequently has a day or two lag before I see it. So I was actually planning to finally get around to the Las Vegas courthouse attack because I've got a lot to say on that issue. I've just been procrastinating, but since you posted this in Discord, I had to jump on it today. So thanks, Paul. In a good faith attempt to resolve this matter without litigation and to avoid drawing further attention to Ms. Guillard's utterly baseless statements, Professor Scofield sent cease and desist letters to Ms. Guillard on November 28th, 2022 and December 8th, 2022. You can always blame it on the snow. And yeah. I don't understand. Is it delusion that provides this unfounded confidence in nonsense? Is it delusion? Is it just hubris? I don't get it, but it is worrying. And like I said, I'm still going to make a video on this. I'm just going to say he's lucky to be alive. I'm going to bring up an example where it happened here and it didn't go the same way. That defendant didn't get to face attempted murder charges, is all I'll say right now. Ms. Guillard received these letters and promptly disregarded them, instead choosing to continue spreading false information for her own pecuniary gain. Given Ms. Guillard's willful disregard of the cease and desist letters, Professor Scofield filed her complaint, ECF number 1, asserting 2 defamation claims, one relating to Ms. Guillard's false statements that Professor Scofield was involved in the murders, and another relating to Ms. Guillard's false statement that Professor Scofield was romantically involved with one of the victims. The factual history of this matter is set forth in more detail in the concurrently filed statement of facts, which is incorporated herein by reference as if set forth in full. Procedural history. Professor Scofield filed her 2-count complaint on December 21st, 2022. Ms. Giard failed to answer or otherwise respond to the complaint within the time called for under the Federal Rules of Civil Procedure, and pursuant to Rule 55A, Professor Scofield filed a motion for clerk's entry of default on January 19th, 2023. I can't believe that was 1 week short of a year ago. That's just wild how time flies. A clerk's entry of default was filed on January 27th, 2023. After failing to respond to the complaint and being found in default, Ms. Giard filed a motion for relief from judgment and an answer, affirmative defenses, and counterclaims on February 16th, 2023. Professor Scofield responded by filing a motion for default judgment on February 17th and filed a motion to strike Ms. Giard's answer, affirmative defenses, and counterclaims on February 27th. On April 26th, the court issued an order granting Ms. Giard's motion to set aside entry of default, granting Professor Scofield's motion to strike, and denying as moot Professor Scofield's motion for default judgment. In granting Ms. Giard's motion, the court reasoned that her failure to timely respond to plaintiff's complaint was most likely an unintentional oversight caused by self-serving carelessness, and that although the court did not condone it, such failure did not amount to bad faith with an intention to take advantage of the opposing party, interfere with the judicial decision-making, or otherwise manipulate the legal process. And I think her actions going forward, even though in that motion she promised to follow the rules, have shown that the judge got that one wrong, or at least she analyzed it wrong. The judge's reasoning in setting aside the default, frankly, was legally sound, but in finding that, yeah, it wasn't a self-serving delay, yeah, that's been proven to be BS many times over. The court also found that Ms. Giard satisfied the low meritorious defense hurdle and that setting aside the entry of default would not prejudice Professor Scofield, except to the tune of $100,000 in legal fees. And we have footnote 2. When the court set aside Ms. Giard's default, it also wrote, defendant represents that, going forward, she will prioritize court rules, orders, and actions and file timely actions. The court intends to keep defendant to her word. Ms. Giard has not kept her word. She represented to the court on February 16th that she would prioritize submitting filings timely, but since then, she failed to file timely responses to plaintiff's motion for default judgment, plaintiff's motion to strike answer, plaintiff's motion for sanctions, plaintiff's motion to quash, and plaintiff's first set of interrogatories, requests for production, and requests for admission. So that's what I was just saying. She promised to abide by the rules and meet the deadlines, but that's 5 examples of her ignoring the rules, ignoring deadlines since she made that promise. What does that tell me? It tells me that Ashley Giard is a lying liar who lies, at least as far as this. Ms. Giard refiled her answer, affirmative defenses, and counterclaims on May 16th, 2023, and on June 6th, Professor Scofield filed a motion to dismiss Ms. Giard's counterclaims. The court heard argument on Professor Scofield's motion to dismiss on July 21st and issued an order dismissing Ms. Giard's counterclaims on August 8th. As this court noted in its order dismissing Ms. Giard's counterclaims, defendant merely responded that she believed her allegations about plaintiff were true and that, with discovery, can find evidence that bears this out. To begin, defendant cannot use discovery as a fishing expedition to find facts that might validate her counterclaims. This ready, fire, aim approach is not permitted under the federal rules of civil procedure. Reminds me, as you all know, I'm a Star Wars fan, wearing my Mandalorian and Grogu shirt today. That this is like in Star Wars Rebels, where I realize most of you haven't seen Rebels, but you've been introduced at least to the character Ezra in Rebels. He was the Jedi on Ahsoka. But when Clone Captain Rex was teaching Ezra about blaster fire, his advice was aim, then shoot. Just like the judge here. It's ready, fire, aim is not permitted under the federal rules of civil procedure. You need to aim, then shoot. And that, you've got it, Reflections. I realize Star Wars animation isn't for everyone. My best friend hates it. I think, so Clone Wars has, like, individual arcs of the Clone Wars are the best Star Wars. So like the Umbaran arc, the Mortis trilogy, the final 4 episodes, the Siege of Mandalore. That's the best of Star Wars. But start to finish, I think Rebels is actually the best Star Wars. It tells a story better than any of the Star Wars movies. It's just really good, I think. So, and that's it. I'm not, like, I don't belong to many fandoms, but Star Wars, I just nerd out a little bit too much. So on August 22nd, 2023, Ms. Guillard filed a motion to set aside the court's order concerning the dismissal of her counterclaims, which this court also denied. And I should just say, you know, I don't have a P.O. box, but if anyone wants to buy me the Lego Venator Star Wars set, you know, it's only $750, but I'm happy to have that sent directly to my house. No P.O. box included. Not that I have a space to put a 3-foot long Star Destroyer. Professor Scofield served Ms. Guillard with discovery requests, including requests for admission, interrogatories, and requests for production pursuant to Rule 36 on June 20th, 2023. Ms. Guillard's responses to those requests for admission were due no later than July 20th. Ms. Guillard did not respond to those discovery requests, including the requests for admission by July 20th. Professor Scofield then filed her original motion for partial summary judgment on October 6th, based on Ms. Guillard having, as a matter of law, admitted to all required elements of a defamation per se claim through her failure to respond to any requests for admission. Ms. Guillard did not respond to any of those discovery requests until December 15th, 2023, after the court, sua sponte, allowed her to do so during a December 7th status conference. The court also allowed Professor Scofield to file an amended motion for summary judgment after Ms. Guillard served any late answers to Professor Scofield's requests for admission. And once again, I think the court was wrong to do that. I get that Ashley Guillard is pro se, but she just completely ignored discovery. I mean, she knew that discovery was a thing because she said in opposing the motion to dismiss her counterclaims, well, I don't have any of that evidence now, but I can get it in discovery. Discovery is a two-way street. If you can get things in discovery, your opposition can get things in discovery. And if you ignore discovery, you're going to have a bad time. Unfortunately, the court gave her an out. They said, well, yeah, you can file your responses 3 months later, 4 months later, whatever, however late it was. What was it? July, 5 months late. You can file 5 months late. That's fine. That's dandy. That's aggravating. That's maddening. That's just unfair. Absolutely unfair. And Causeless Rebel, I'm glad you mentioned that. When we finish, go back to the beginning of this video because we discussed that and how I don't understand why Michael Me signed up for it or why Delete Laws did it. But it wasn't worth making a video on its own. So we tagged it on the beginning of this one. So be sure to watch the beginning of this once we're done. Although Ms. Guillard served responses to Professor Scofield's request for admission on December 15th, she did not ever respond to Professor Scofield's interrogatories or requests for production. Professor Scofield sent a deficiency letter on December 20th, requesting responses by December 29th. Ms. Guillard sent an email on January 1st, 2024, stating that she was on vacation when the deficiency letter was sent, and that she would get back to Professor Scofield's counsel by the end of the week. Ms. Guillard still has not responded. So she finally, 5 months late, responded to the request for admission, but she ignored the rest of the discovery requests. Yeah, and discovery's closed now. But, you know, she complains about Facebook not answering her subpoena. She complains that Professor Scofield, in requesting, Professor Scofield subpoenaed information from the University of Idaho, but because Professor Scofield didn't subpoena the things that Ashley Guillard wanted from the University of Idaho, that was evidence that Professor Scofield was hiding stuff, despite the fact that Ashley Guillard could have sent her own subpoena to the University of Idaho. I get it. Lawyering is hard, especially when you're not a lawyer. But that's why you shouldn't commit intentional torts against people. The only intentional torts you should commit is giving your neighbor cake, because cake is always appreciated. But when you commit intentional torts, you should have a budget for a lawyer. And, well, frankly, if you're going to put yourself out there, you should have a budget for a lawyer. Just ask the girlies, because from what I've seen, they have not committed an intentional tort. Janet is just Janet. But I still need to put together that video protecting yourself as a content creator, because there's so many areas you need to protect yourself on. You've got to protect yourself from defamation. You've got to protect yourself from copyright. You've got to protect yourself if you're selling merch. You've got to protect yourself. You've got to protect yourself in your contracts with sponsors. So yeah. So legal standards. Rule 56A provides that a party may move for summary judgment, identifying each claim or defense, or the part of each claim or defense on which summary judgment is sought. Federal Rule of Civil Procedure 56A. The emphasized portion of Rule 56A permits parties, like Professor Scofield here, to move for summary judgment on liability while leaving the amount of damages for trial. CEG, United States Securities and Exchange Commission versus Cutting, District of Idaho, 2022, which granted a summary judgment motion on liability. The standard for summary judgment is familiar. Summary judgment is appropriate when viewing the evidence in the light most favorable to the non-moving party, there is no genuine dispute as to any material fact. That's Zetwick versus County of Yolo, 9th Circuit, 2017. So I forgot to mention that standard at the beginning. I talked about the no undisputed facts, but the evidence is viewed in the light most favorable to the non-moving party. So in this case, Professor Scofield brought the summary judgment motion, so she is the moving party. And by process of elimination, Ashley Guillard is the non-moving party. So this is kind of the same as a 12b6, a motion to dismiss. So remember, in a motion to dismiss, the court has to take all the facts in the complaint as being true. But they're not undisputed facts like in a summary judgment motion, because you're not going on the pleadings from both parties and comparing them to say, yeah, this fact is disputed, this one isn't. You're just going on the complaint. But just the same, the party that filed the motion to dismiss, the 12b6, is the moving party. So the party that brought the complaint is the non-moving party. And so by taking their statements of fact as true, that's the light most favorable to them. It is amusing, Yolo County. It was not always amusing, though. It's only in the last, 10, 15 years that it became amusing. And I assume it's a Spanish name. So, correct me if I'm wrong, but at least when it was named, would it have been something like yo? I don't, as you saw earlier, I don't speak French. I also don't speak Spanish, but in Spanish, doesn't the L in cases like this take kind of a Y sound? Either way, it's amusing now. So, and then Federal Rule of Civil Procedure 56A, the court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. Where the record taken as a whole could not lead a rational trier of fact to find for the non-moving party, there is no genuine issue for trial, and summary judgment is appropriate. And that's Zetwick, which quotes Ricci versus DiStefano, which is a Supreme Court case from 2009. The district court must not only properly consider the record on summary judgment, but must consider that record in light of the governing law. And that's also Zetwick, which in that case is quoting Anderson versus Liberty Lobby, Inc., which is a Supreme Court case from 1986. In ruling on a motion for summary judgment, the court must only consider admissible evidence. And that's Orr versus Bank of America, 9th Circuit, 2002. The party moving for summary judgment bears the initial burden of showing the absence of any genuine issues of material fact. That's That's Celotex Corp versus Catret, 1986. The burden then shifts to the non-moving party to identify specific facts showing there is a genuine issue of material fact. See Anderson. The mere existence of a scintilla of evidence in support of the plaintiff's position will be insufficient. There must be evidence on which the jury could reasonably find for the plaintiff. So that's the standard. Now we have the argument. Ms. Guillard's responses to requests for admission do not raise a genuine dispute of material facts. They support an award of summary judgment to Professor Scofield. And we'll get to the statement of undisputed material facts after, but just I'm going to preview at least part of it, because as you'll see, even by responding to the request for admission, she hasn't brought any dispute, because before it was, please admit that you don't have any actual evidence other than your tarot reading and spiritual intuition. And that was deemed as admitted. But now, just as an example, we'll find it. So, line or paragraph 51 in the statement of facts. Ms. Guillard has no evidence that she ever communicated with JD, the University of Idaho student she first claimed Professor Scofield hired to execute the murders, or Brian Koberger. She maintains that she cannot admit or deny this matter. Many people have anonymously contacted me by way of electronic communication. So, I mean, she can't admit or deny. She has to admit it because she has no evidence. She hasn't communicated with him. But, you know, I was contacted anonymously, so, because, yeah, that's not going to work. But that's just an example of how even her responding to the request for admissions, but still not the interrogatories or request for production, but even then, she hasn't brought any dispute as to the facts. Through her request for admission, Professor Scofield sought admissions regarding 1. Ms. Guillard making public statements that Professor Scofield was involved with the murders of the 4 students and that Professor Scofield had an affair with one of the students. 2. The falsity of those statements. 3. That the basis for Ms. Guillard's statements was her spiritual research, intuition, and instincts. 4. That she was not aware of any physical evidence or written information linking Professor Scofield to the murders or to having an affair with KG, one of the students. Through her responses to Professor Scofield's request for admissions, Ms. Guillard now claims that she was just announcing the results of a tarot card reading when she made her TikToks and posted them on the internet, stating that Professor Scofield was involved with the murders and that Professor Scofield had an affair with one of the students, but she admits posting them. She also admitted that she continued to state publicly that Professor Scofield was involved with the murders and had an affair with one of the students, even after she received a cease and desist letter from Professor Scofield's counsel, and after she knew that Moscow, Idaho Police Department had issued a press release saying that Professor Scofield was not involved in the murders. She also admits she has never received any information communicated to her orally that Professor Scofield ever met the victims. Yeah. I've received electronic communication that I've won the lottery. I didn't win the lottery, but it's also, as mark my place there, going back up to the standards. In a ruling on a motion for summary judgment, the court must only consider admissible evidence. That's the Ninth Circuit case, Orr versus Bank of America. Anonymous electronic communications. Well, that's hearsay from an unknown source. That's probably not going to be admissible. I mean, it might not to prove the truth of the matter asserted, but just to show that she received the communications that she received, and so her statements weren't completely baseless. So she can't use them to prove that Professor Scofield did commit the murders, but she might be able to get them in just to show, look, I received these and I could reasonably rely on them, that they were telling me the truth, and therefore I didn't commit defamation because, you know, I reasonably relied on them. But you know, it's, you receive anonymous communications telling you the things you want to hear. You don't do any actual research. What could you say that's reasonable reliance? Because I wouldn't. But finding our place again. In response to requests for admission, asking her to admit she had no written information or physical evidence showing that Professor Scofield ever met the murdered students, Ms. Guillard stated that she could not admit or deny because discovery is still pending. Public information from the victim's social media may show that the plaintiff met the murdered students. Ms. Guillard responded similarly when asked to admit she knew of no physical evidence linking Professor Scofield to the murders, or that she was not aware of any physical evidence showing Professor Scofield had an affair with KG. She stated, "I deny this matter." There's plenty of evidence to be discovered during the civil discovery process or criminal trial. In response to requests for that whole thing was her response. I deny this matter. There's plenty of evidence to be discovered during the civil discovery process or criminal trial. So you're asked to admit that you knew of no physical evidence linking Professor Scofield to the murders, and that you're not aware of physical evidence showing that Professor Scofield had an affair. Your denial confirms that you didn't have any of this, because I deny this matter. There's plenty of evidence to be discovered. To be discovered means you do not have it. That's what they were asking. Do you have any information about this? If it's to be discovered, that's to be determined. You do not have it. So you lied. You had to admit that you did not have this. Besides which, you say there's plenty of evidence to be discovered, except you say this on the day that discovery closed. Who are you going to discover it from? Short of harassing the victims' families, harassing the Moscow Police Department, you know, is Brian Koberger your prison pen pal? Where are you going to discover this? Professor Scofield doesn't have it for you because it doesn't exist. This bitch pisses me off. In response to requests for admission asking Ms. Giard to admit she had never communicated with JD or Brian Koberger, she responded, "I cannot admit or deny this matter. Many people have anonymously contacted me by way of electronic communication." So you think that the nebulous JD or Brian Koberger are the senders of this anonymous information? Okay. In response to requests for admission asking Ms. Giard to admit her statements were false, Ms. Giard denied the request for admission and stated that Professor Scofield has not proven that she did not have an affair with KG or that she was not involved in the murders. You haven't brought any evidence showing that she did. Professor Scofield has stated, "I did not do any of these things." How is she supposed to prove a negative? Her statement is evidence. It's testimony. Testimony is evidence. I get so tired of people. You watch the traffic court. Watch Judge Webster in Kansas with Jay Regier bought 5,000, and they don't bring the dash cam. They just bring the trooper testifying. "Yeah, I saw them. They were speeding. They were within my jurisdiction. I pulled them over. I wrote them a ticket. Here we are." And then the defendant, "Well, you've got to find in my favor because there's no evidence." It's like the testimony, that was the evidence. That was the evidence. Where's your evidence that you weren't speeding? Just like here, Professor Scofield saying, "I did not do this. I did not know any of them." That's testimony. "I was in Oregon at the time of the murders." That's testimony, but I'm sure she actually did provide the receipts. Ashley Giard saying, "The tarot cards told me." She has no evidence. She has brought nothing. But her response to the request for admission is, "Well, I deny it. I deny that my statements were false because you haven't proven that they're false." And exactly, Dave, it's like asking, "Do you still beat your wife?" "No." "Oh, so you did beat her before?" "No, I never beat her. I don't have a wife." But once again, drives me nuts. Finally, Ms. Giard admitted that she did not have any written information showing that Professor Scofield ever met JD, the University of Idaho student that Ms. Giard publicly stated Professor Scofield hired to commit the murders. She stated, "As of today, December 15th, 2023, this matter is admitted. However, discovery is still pending." Except it wasn't. Discovery closed that day. So even your admission, you have I mentioned I don't like Ashley Giard? I think she is a terrible person. I look forward to Professor Scofield winning and winning big, even if she won't ever collect a penny. I also look forward to JD filing his own lawsuit, his own defamation claims against Ashley Giard. course, as a student, I don't, unless he comes from a wealthy family, this shit's expensive. So, in short, Ms. Giard has admitted that she has no affirmative facts to indicate in any way that Professor Scofield had an affair with KG or was involved in the murders, nor will she develop any. The discovery deadline was December 15th, 2023, the same date that Ms. Giard served her responses to Professor Scofield's requests for admission. Thus, fact discovery is closed. Getting my mouse to switch screens can be a pain sometimes, but the original Star Wars movie, I do recommend it. The prequels have some issues. The sequels can be problematic, but I find all of them entertaining. I find the original series obviously the best of the movies. Although, well, Rogue One is the best movie, but that's beside the point. Andor is the best live-action Star Wars television series. So, the effect of an admission under Rule 36 is clear. A matter admitted under this rule is conclusively established. Rule 36B. Taken together, Ms. Giard's December 15th, 2023 responses to Professor Scofield's requests for admission conclusively establish the following facts. Ms. Giard stated publicly that Professor Scofield was involved with the murders of KG, MM, XK, and EC. So she made a statement. That's one of the elements of defamation. Conclusively established. That one's easy, though. Ms. Giard publicly stated that Professor Scofield had an affair with KG. Conclusively established. But that one, once again, is easy. Ashley Giard doesn't contradict that. Her response was basically, yeah, I said what I said. Come at me. Ms. Giard continued to make such public statements after receiving a cease and desist letter from Professor Scofield's counsel and after becoming aware that the Moscow Police Department had issued a press release stating that they did not believe Professor Scofield was involved in the murders. Ms. Giard has no evidence or facts showing that Professor Scofield was involved in the murders. Ms. Giard has no evidence or facts showing that Professor Scofield had an affair with the student. So the facts conclusively established by Ms. Giard's admissions, the TikToks she posted, and Professor Scofield's declaration demonstrate Professor Scofield's entitlement to judgment as a matter of law. In the defamation action, a plaintiff must prove that the defendant, 1, communicated information concerning the plaintiff to others, 2, that the information was defamatory, and 3, that the plaintiff was damaged because of the communication. That's Clark versus Spokesman Review, Idaho Supreme Court, 2007. A defamatory statement is one that tends to harm a person's reputation, usually by subjecting the person to public contempt, disgrace, or ridicule, or by adversely affecting the person's business. That's Elliott versus Murdoch, Idaho Supreme Court, 2016. Moreover, the Idaho Supreme Court has recently held that a statement is defamatory per se, so defamatory as a matter of law, if it imputes to another conduct constituting a criminal offense. If the offense imputed is of a type which, if committed in the place of publication, would be A, punishable by imprisonment in a state or federal institution, or B, regarded by public opinion as involving moral turpitude. Well, both of those are met here. Well, at least as far as the murders go, murder is punishable by imprisonment in a state or federal institution. You there are people imprisoned in federal prison for murder, but that's generally, bigger stuff like serial killers. But moral turpitude, well, murder, I believe, is a crime of moral turpitude, but theft and fraud and stuff is moral turpitude. But having an affair is moral turpitude. So, and that was Sirki versus Sirki from the Idaho Supreme Court in 2020, which was quoting from the Restatement of Torts, Section 571. So, like I said earlier, that's the Idaho Supreme Court basically adopting Section 571 of the Restatement of Torts as valid law in Idaho. So same thing applies to the restatements of contracts, the restatements of whatever else. I'm pulling a blank, but there are restatements of other things. But it also applies to like the rules of professional conduct. Although that's generally, well, I think it's the Supreme Court adopts those in conjunction with the bar, but the Supreme Court decides that. For the sovereign citizens out there, the UCC. The UCC is not law, actually. The UCC is the same as the Restatement of Torts. It's put together by eggheads saying this is what the law should be. Now, most states have adopted it as the law. The only state I know of where it actually is the UCC is Utah, because Utah, it's the Utah Commercial Code. But in Texas, it's going to be the Texas Commercial Code. Now, Louisiana has not adopted as much of the UCC as others. I believe, well, it's the state legislatures that have adopted it, because here in Utah, it is specifically statutory. So under this test, the proper focus of a defamation per se inquiry is the nature of the conduct imputed. And if criminal conduct is imputed, and that conduct amounts to either a crime punishable by imprisonment or a crime of moral turpitude, the allegedly defamatory remarks are actionable as defamatory per se. I've got a hair or an eyelash or something. It was bothering me. Similarly, a statement is defamatory per se if it ascribes to another conduct, characteristics, or a condition that would adversely affect her fitness for the proper conduct of her lawful business, trade, or profession. That's Restatement of Torts, Section 573. Or it imputes serious sexual misconduct to another. That's Section 574. And see Yoakum versus Hartford Fire Insurance Company, Idaho Supreme Court 1996, which recognized that statements are defamatory per se if they impute to the plaintiff either a criminal offense, a loathsome disease, a matter incompatible with his trade, business, profession, or office, or serious sexual misconduct. That's citing the Restatement of Torts, sections 570 through 574. Statements that rise to the level of defamation per se do not require proving special damages. That's Sirki. Whether a statement is defamatory per se is a question of law for the court. So it's not a question of fact, it's a question of law. It's for the court to decide, not for the jury to decide. But then it's a question for the jury to decide how much to pay in damages. It's just a matter of law, whether it's per se. Admissions made under the Federal Rule of Civil Procedure 36 can serve as the factual predicate for summary judgment. That's United States versus Kasuboski, 7th Circuit, 1987. Indeed, because evidence inconsistent with a Rule 36 admission is properly excluded, summary judgment may be granted solely based on Rule 36 admissions, even where other evidence might contradict those admissions. That's 999 versus CIT Corp, 9th Circuit, 1985. And we have footnote 3, which says, to be clear, there is no evidence contradicting Ms. Guillard's admissions here. So they're saying, even if there were contradictions to the admissions are good enough for summary judgment. But there are no contradictions here. So we don't even have to consider them. But even if there were, the admissions are good enough to act as a basis for summary judgment. So Professor Scofield is entitled to judgment as a matter of law on count 1, and that's the claims that she's a murderer. Count 1 concerns Ms. Guillard's false and defamatory statements that Professor Scofield was involved in the murders of the students. Beginning on or about November 24th, 2022, Ms. Guillard posted videos on TikTok in which she falsely stated that Professor Scofield was responsible for, ordered, or was otherwise involved in the 4 students' deaths. Ms. Guillard's publishing of these videos on TikTok constitutes a communication as a matter of law, and because Ms. Guillard's statements impute criminal conduct for which the punishment is greater than 1 year imprisonment, the statements are defamatory per se. Accordingly, Professor Scofield is entitled to summary judgment on count 1. And they mention punishment is greater than 1 year imprisonment because the standard we discussed above was for defamation per se, the crime has to be one that is punishable by imprisonment in a state or federal institution. Generally, the rule is you serve sentences of above 1 year, so felonies, in state prison. Less than a year are served in the county jail. So a county jail under this rule is not considered a state prison. Well, I mean, it's not, but you know, there could be other laws where it just says imprisonment and doesn't specify. But since it specifies state prison, that would indicate for felonies, for punishments greater than a year. So as to the count 1, Ms. Guillard communicated information regarding Professor Scofield to others. Ms. Guillard has admitted that she publicly stated that Professor Scofield was involved with the murders of the 4 students. That's Statement of Facts, paragraph 19, and 40 and 42. So just as an example, I mentioned we'd see lots of that. So I realize I haven't pointed it out every time, just periodically pointing out it's cited there. This admission conclusively establishes that Ms. Guillard communicated information concerning the plaintiff to others. That's one of the Circe elements. While few cases dwell on what it means to communicate information concerning the plaintiff to others, that's Circe, there is no doubt that Ms. Guillard's posting of videos on TikTok satisfies this element. And like that was my hypothetical earlier, remember. If Guillard could bring forward information saying, yeah, posting videos on TikTok, the courts have already ruled is not publishing to others, that would be a dispute, a valid dispute. So summary judgment wouldn't be appropriate. But you know that there's nothing to say that posting on TikTok isn't communication. Now, you might say, well, Joe, she posted, but it didn't get any views. I mean, it did get views, but this is another hypothetical. That wouldn't matter. It was still published where others could see it. It was available. So the element of publication or communication requires the defamatory statement be communicated to a person other than the person defamed. That's Irish versus Hall, Idaho Supreme Court 2018, which was abrogated on other grounds by Sirkey, meaning it's not valid, good case law for its main holding, but it still can be quoted for other things. In both print and internet publishing, information is generally considered published when it is made available to the public. So, like I said, when it's made available to the public. So even if it had 0 views, it was made available to view. So let's say you upload a video onto YouTube and it's a private video. No one can see it. That's probably not published. But let's say you do an unlisted video, and so you can't find it through the search function. You can't find it on the channel's page, but if you're given the direct link, you can go to it. That's probably published, but there might actually need to be litigation on that one to know. But it probably would be. But once again, we'd have to find out, because that might be a valid challenge. It's an opportunity to establish case law. So thus, once information has been published on a website or print media, there is no further act required by the publisher to make the information available to the public. Even absent Ms. Guillard's admissions, there can be no dispute that she communicated information concerning Professor Scofield to others. Beginning on or about November 24th, 2022, Ms. Guillard posted TikTok videos to her account in which she falsely stated, both directly and indirectly, that Professor Scofield was responsible for, involved in, and ordered the murder of the 4 students. Over the following 4 days, Ms. Guillard posted additional TikToks in which she continued to falsely assert that Professor Scofield ordered and planned the murders of the 4 students. These TikToks put more details to Ms. Guillard's false theory, as Ms. Guillard claimed that Professor Scofield and a different student at the University of Idaho, JD, together planned the murders. And footnote 4, as with the plaintiff's complaint, this memorandum uses the initials JD to protect the individual's privacy and not perpetuate Ms. Guillard's false and defamatory statements. So compensation is not a factor. It basically, just like in crimes, motive isn't an element of the crime. Now, the prosecutors and the police, they like to know the motive. The jury likes to know the motive. The defendants will often say, you haven't proven a motive, so how can you possibly prove me guilty? But the motive isn't a factor. It's a nice to have as opposed to a requirement. And so here, basically, compensation is the presumed motive of Ashley Guillard. Although she says she didn't receive compensation, I believe clout was her motivation, because she's a clout goblin. And so I think that's the motive, but that doesn't have to be proven. So it's argued about, and Guillard tries to say, well, they defamed me by saying I did this for compensation, or they can't prove their case because they said I did this for compensation, and I didn't even get paid. I'm not monetized. And it's like, but you do paid tarot readings, and you did this to try to get more paid tarot readings. So that would be your compensation, the clout, the advertisement. But it's just, it's not a factor here. So in one of her November 28th TikToks, Ms. Guillard included text stating, I don't care what y'all say, JD and Rebecca Scofield killed the students. Rebecca was the one to initiate the plan and hired JD. In all, Ms. Guillard herself estimates that she posted over 100 TikTok videos of her supposed findings in which she communicated her baseless theory that Professor Scofield was in a relationship with KG, that broke up, and that she initiated the murders, planned the murders, and hired JD to help carry the plan out. And Ms. Guillard has continued to make defamatory statements even after Professor Scofield's November 28th and December 8th cease and desist letters. Since December 1st, 2022, Ms. Guillard has posted additional TikToks stating, among other things, that Rebecca Scofield is going to prison for the murder of the 4 University of Idaho students, whether you like it or not. And I'm not worried about Rebecca Scofield suing me because she will be using her resources to fight 4 murder cases. And she ordered the execution, the murders of KG, well, of the students. And my ginger ale is gone, so it's water time. Luckily, Salt Lake, at least the east side of Salt Lake, has wonderful water straight from the mountains. And that's perfectly fine, Lynn. So the number of viewers, like I said, it's not relevant. It's posted for the public is enough. As I mentioned, she didn't have to get any views whatsoever. Just putting it on TikTok and making it public, that's enough. That's published. So moreover, Ms. Guillard's TikToks were, in fact, viewed by thousands, if not millions of people. So there you go. It didn't receive 0 views. It didn't receive a trickle of views. It received lots of views. Some of her TikToks defaming Professor Scofield had thousands of likes, indicating that a third party had viewed the video and liked it. Finally, Ms. Guillard, who is representing herself and signing all pleadings in this case, has repeatedly admitted that she has publicly stated that Professor Scofield was responsible for, involved in, and ordered the murder of the 4 students. Of course, those pleadings that she has signed, even though she has repeatedly realleged and confirmed that she made those statements, those wouldn't count as defamation, even though, they're nasty statements, but they're made within litigation, so they're privileged statements. Not in the way Ashley Guillard thinks things are privileged, because she thinks, well, there was the criminal case ongoing that I'm not involved in, she's not involved in, no one here is involved in. It's the state of Idaho versus Brian Koberger. But that granted me privilege to say any foolish thing I wanted. So, and as for those repeated statements, CEG, ECF number 32 at 3, where Ashley Giard in the pleading said, "The truth is, Rebecca Scofield is a serial killer who successfully evaded suspicion of her crimes for months. On November 24th, 2022, Ashley Giard used her psychic abilities, spiritual acuity, and investigative skills to uncover the motive and details that led to the murder of the students. She posted her findings on social media." And she said the same thing in ECF 35 and ECF 36, where she said, "On December 12th, 2022, Ashley Giard responded to the demand letter by posting another TikTok video that she believed that she did not make any false statements about Rebecca Scofield and did not have to follow their demands." And I'll just point out, Ashley Giard says, "The truth is, Rebecca Scofield is a serial killer." Like, even if your allegations are true, that doesn't make her a serial killer. Because to be a serial killer, the generally accepted truth is, yeah, you have to have 3 or more killings, and 4 is greater than 3. I realize that, but it has to be in separate incidences. Here, since it was all done as one continuous act, basically, she would be a spree killer, not a serial killer. She's obviously not either of those things, but just in the interest of being accurate, her accusations are wrong, because she's accusing her of being a spree killer, not a serial killer. Unless there's other murders that she knows about but hasn't told us. I mean, I wouldn't believe her on those either, but, you know, you do you. That reminds me of another video I might be making, but I'm not going to spoil it here. But I might talk about serial killers slightly if I make that video. Where am I? Thus, Ms. Giard's admissions and the TikToks themselves establish beyond dispute that she communicated information about Professor Scofield to others. And that's, once again, Irish versus whatever it was, Idaho Supreme Court, which says, "In both print and internet publishing, information is generally considered published when it is made available to the public." That's actually a good question. How did I get it? If you're hiring someone, like is a contract killer a serial killer? But if you serially hire a contract killer to commit murders, because you'd be charged with first-degree murder yourself and solicitation to commit murder and various other charges, conspiracy. But I don't know. I don't know if that makes you a serial killer or just a serial contractor of killers. Not that it's, it's really a distinction without a difference, but that is an interesting thought experiment. Ms. Giard's communications were defamatory per se. Ms. Giard's statements unambiguously impute to Professor Scofield conduct constituting a criminal offense that would be punishable by imprisonment in a state or federal institution. And that's, once again, from Sirke. Ms. Giard variously asserted, falsely, that Professor Scofield killed the students, was the one to initiate the plan, and hired the supposed hitman. ordered the murder of the 4 University of Idaho students, and broadly claimed that Professor Scofield was involved in the killings. Indeed, Ms. Giard has admitted that she stated publicly that Rebecca Scofield was involved with the murders. Ms. Giard's admissions and the uncontroverted evidence in this case conclusively establish that Ms. Giard's statements impute to Professor Scofield conduct constituting a criminal offense that would be punishable by imprisonment in a state or federal institution. And that's footnote 5. See Idaho and Code annotated sections 18-401, murder defined, 404, 4004, punishment for murder, 4006, manslaughter, 4007, punishment for manslaughter, 1701, criminal conspiracy defined, 204, principles defined, 205, accessories defined, 206, punishment of accessories, 2001, solicitation defined, and 2004, punishment for solicitation. So that would basically, that's covering all the bases, saying, hey, she's accusing her of being a murderer. That is punished by imprisonment of more than a year. It's a felony. Manslaughter, punished by more than a year. It's a felony. Criminal conspiracy, punished by more than a year. And in this case, she would be a principal. And JG, can't remember his initials, would be the accessory in this case. But it's a felony, punishable by more than a year. Or I guess here she'd be the accessory, punishment of accessories. I clearly haven't looked at principles defined and accessories defined. But solicitation to commit murder, defined. Punishment for solicitation, more than a year. So her accusations could constitute any one of these crimes. And every one of them has punishment of more than a year. Therefore, accusation of any one of these, which she's basically accused her of all of these, is defamatory per se. So, accordingly, Ms. Giard's false statements concerning Professor Scofield's purported involvement are defamatory per se as a matter of law. Well, that's okay. I don't like the way that was worded. Defamatory per se as a matter of law. That's like saying defamatory as a matter of law, because per se basically means as a matter of law. So saying defamatory per se as a matter of law is saying defamatory as a matter of law, or defamatory per se. And this court should determine as a matter of law that Ms. Giard is liable to Professor Scofield on count 1. And that's Federal Rule of Civil Procedure 56A, which permits summary judgment on a part of a claim like liability, and cutting the case which granted a motion for summary judgment on liability, which is what Professor Scofield is after here. Professor Scofield is entitled to judgment as a matter of law on count 2, and that's the count about allegations of an affair with a student by a professor. As with count 1, Ms. Giard's admissions established as a matter of law that Professor Scofield is entitled to judgment on count 2. Ms. Giard admitted to posting TikToks containing assertions that Professor Scofield was in a romantic relationship with one of the victims, KG, although she now states that she was just announcing the results of a tarot card reading. She also has now admitted she currently has no evidence to support her false assertions. But, Your Honor, I denied it because I could find it in discovery, even though I don't have it now. So it's undisputed. In her December 15th, 2023 responses to Professor Scofield's request for admission, she acknowledged that she does not currently have any facts showing that Professor Scofield even knew KG. The subpoena responses from the University of Idaho confirm the absence of any communication or interaction between Professor Scofield and KG. Although that's not good enough for Ashley Giard, because she thinks Professor Scofield should have requested the things that she wanted, that Ashley Giard wanted. And Paul Berry, get my mouse there. Can Professor Scofield get a gag order or protection order? No, that would be prior restraint. She can just get more damages. Not that that matters, because Ashley Giard is probably judgment proof. But basically, if she keeps talking garbage, you go to the court and file a new lawsuit, and you say, hey, look, I've got res judicata on this claim. I've already proven in court that this is false, and she has published a new statement. I want more damages. And that's basically what you do, because courts, it's basically, in most cases, it's going to be prior restraint, telling someone, you got to shut up. You can't talk about this. I can punish you if you talk about it later on, and that punishment is monetary, but I can't tell you not to talk about it. And it's this isn't like a case of intimate partner violence, or that there is no actual physical, or that there's no harassment. She's not communicating to Professor Scofield. She's talking about Professor Scofield, and that's kind of the difference here. It's like, delete laws. He can get his panties in a twist about me talking about him and talking about the case, but the court can't tell me not to. The court could tell me not to contact him, which I haven't. I've never contacted delete laws. Not that he's tried to get me to stop, but it's the same thing, basically. Ms. Giard communicated information concerning Professor Scofield to others. For the same reasons as discussed above in reference to count 1, Ms. Giard's TikToks that contained false assertions that Professor Scofield had a romantic relationship with KG constitute communications concerning Professor Scofield. As a matter of law, therefore, Ms. Giard has admitted to the first element of the defamation claim asserted in count 2, and that's citing Irish. Once again, the publication element. Ms. Giard's false statements that Professor Scofield maintained a romantic relationship with a student are defamatory as a matter of law, per se. Defamation per se. A defamatory statement is one that tends to harm a person's reputation, usually by subjecting the person to public contempt, disgrace, or ridicule, or by adversely affecting the person's business. That's Sirke once again. In addition to statements imputing criminal conduct, the Idaho Supreme Court has recognized 3 other categories of statement that are defamatory per se, and therefore do not require proof of special damages. That's Barlow versus International Harvester Company, Idaho Supreme Court, 1974, which says defamatory utterances regarding an individual are slanderous per se if they fall into one of 4 categories. And this was also abrogated on other grounds by Sirke. 2 of these other categories are relevant here. 1, utterances which ascribe to another conduct, characteristics, or a condition incompatible with the proper conduct of his lawful business, trade, or profession. That's quoting the Restatement of Torts, Section 573. And see also Restatement of Torts, 573. And then, sorry, that was the Restatement of Torts and then the Restatement Second of Torts. Both Section 573. And number 2, statements that impute serious sexual misconduct to another. That's Restatement of Torts, Second, Section 574. And Yoakum, which is an Idaho Supreme Court case, which recognized that statements which impute to the plaintiff serious sexual misconduct are defamatory per se. Ms. Giard's false statements underlying count 2 are defamatory per se under both of these categories. And so category 1, utterances which ascribe to another conduct, characteristics, or a condition incompatible with the proper conduct of his lawful business, trade, or profession. Her profession, of course, being a professor of history at the University of Idaho. It is incompatible with that profession to have an affair with students. It's against the University of Idaho Code of Conduct. We've seen that. It was included in the discovery responses that it's against the Code of Conduct. So saying that she violated the Code of Conduct through her sexual activity is accusing her of doing things that are incompatible with her profession. And then, of course, the second category, statements that impute serious sexual misconduct to another, well, saying she had an extramarital affair with a student is serious sexual misconduct. So, fits on both grounds. Both are defamatory per se. And of course, you'll notice the Barlow versus International Harvester Company is a case from 1974. So generally, we don't, in any of the litigation, we just constitute everything as defamation. We don't bother generally with the distinction of slander versus libel because it doesn't really matter. It's defamation. The elements are the same other than how it's published, how it's transmitted to others, whether it's spoken or written or recorded or whatever. It doesn't really matter. So in modern times, we just say it's defamation. But you'll notice in this quotation, it says defamatory utterances regarding an individual are slanderous per se. So back in 1974, it was slander per se. But here we're just worried about defamation per se because the distinction doesn't matter. It's defamation. Although in torts in the first semester of law school, they still do test you on slander versus libel because the law is slow to evolve. Ms. Giard's statements ascribe conduct to Professor Scofield that is incompatible with the proper conduct of a professor. First, it cannot be genuinely disputed that a romantic or sexual relationship between a professor and student at that professor's university is conduct incompatible with the proper conduct of the professor's lawful business, trade, or profession. That's citing Barlow once again. Indeed, the incompatibility of a professor-student romantic relationship is enshrined in the University of Idaho's policy concerning consensual romantic or sexual relationships, as we mentioned just a minute ago. That policy states in no uncertain terms that it is the policy of the University of Idaho that no employee shall enter into or continue a romantic or sexual relationship with a student or employee over whom she or he exercises academic, administrative, supervisory, evaluative, counseling, or other authority. I kind of don't like the way that's phrased because yes, you can't enter into, but or continue. It's like, well, what if you're the only person at the university that teaches a certain subject, and your spouse that you have been married to for 10 years enrolls as a student and needs that class? Are you supposed to divorce them so that they have a path to graduation? That doesn't sound right to me. It's like in our legal ethics class during law school, the professor, he's really, you cannot start a romantic relationship with a client. Someone raised their hand. Well, what if you're in a romantic relationship with someone and take them on as a client? Would it be unethical to stop the relationship with them? And he's like, you should probably keep sleeping with that client. So ethics are always situational, but in general, having an extramarital affair with a student that situation is going to be unethical, against the code of conduct. My ethics professor was funny. Moreover, the University of Idaho maintains a policy condemning sexual harassment, which explicitly includes within the definition of sexual harassment behavior that overtly or covertly uses the power inherent in the status of a professor, teacher, or other officer to affect a student's educational experience or career opportunities. Should a professor at the University of Idaho be found to have violated either of these policies, the professor is subject to discipline, including dismissal. But is it against the code of conduct for a professor to murder students? They say it's against the code of conduct for a professor to sleep with students, but it doesn't say anything about murdering them, so we're all good, right? I mean, other than, the fact that that's defamatory per se under the incarceration for over a year standard, but other than that, we're all good. The University of Idaho has implemented these policies for good reason. A romantic or sexual relationship of the kind forbidden by the policy inevitably raises concerns for objectivity, fairness, and exploitation because they have the potential for abuse and damaging consequences. The imbalance of power creates unacceptable risks of exploitation, favoritism, harassment, and bias, both actual and perceived, and thereby impairs the integrity of the professional relationship and the trust on which it depends. And the University of Idaho is not alone in adopting such policies prohibiting romantic relationships between professors and students. A 2014 study found that 84% of the American universities surveyed had some prohibitions on professor-student relationships. And that's an article by Amia Srinivasan titled, "What's Wrong with Sex Between Professors and Students? It's Not What You Think." And it was in the New York Times in September 3rd, 2021. These policies, including the University of Idaho's, indisputably demonstrate that romantic or sexual relationships between professors and students at the same university are incompatible with the proper conduct of the professor's lawful business, trade, or profession. That's the Barlow factor, once again. Accordingly, because Ms. Giard has admitted to making such statements and admitted that they were false, Ms. Giard has admitted that these statements, too, were defamatory per se. Ms. Giard's statements impute serious sexual misconduct to Professor Scofield. So that's the second way in which it's defamatory per se, both incompatible with her trade and impute serious sexual misconduct. Ms. Giard's false assertion, and she doesn't, Professor Giard or Professor Scofield doesn't have to prove both of these factors. Either one would suffice, but she can prove both. So this is the belt and suspenders approach. Her pants aren't falling down. Ms. Giard's false assertions that Professor Scofield was involved in an inappropriate romantic relationship with KG are also defamatory per se because they impute serious sexual misconduct to Professor Scofield. That's Restatement of Torts, Second, Section 574, and Yoakum from the Idaho Supreme Court. This category of defamation per se applies to a statement charging a woman with general charges of unchaste conduct. That's Restatement of Torts, Second, Section 574, Comment B. Undoubtedly, Ms. Giard's admittedly false statements that Professor Scofield was romantically involved with a student constitute charges of unchaste conduct. Moreover, Ms. Giard's false statements are particularly serious here, where Professor Scofield is subject to the University of Idaho's policies concerning sexual harassment and romantic relationships between professors and students. As noted above, these policies would subject Professor Scofield to discipline, including termination of her employment, had she been engaged in such misconduct. Indeed, Ms. Giard well knew that she was asserting Professor Scofield had engaged in serious misconduct in violation of university policy. She showed one of the policies in one of her TikToks. So she can't say, well, I didn't know this was alleging she broke the rules of her employment. She showed that this was an allegation of breaking the rules. The evidence is undisputed, however, that Professor Scofield was not involved in any misconduct and that Ms. Giard's statements to the contrary in her TikToks were false. At bottom, Ms. Giard has admitted to stating that Professor Scofield was romantically involved with a student at the University of Idaho. These statements ascribe to Professor Scofield conduct incompatible with the proper conduct of a professor and impute serious sexual misconduct to Professor Scofield, as expressly noted in the University of Idaho's policies governing romantic or sexual relationships between professors and students. Accordingly, Ms. Giard's statements are defamatory per se as a matter of law, and the court should determine as a matter of law that Ms. Giard is liable to Professor Scofield on count 2. Finally, no facts support any defense that Ms. Giard's statements were true. Truth is a defense to a defamation claim that ordinarily must be proved by the defendant. So this is a burden shifting thing. Your affirmative defense of truth is something you have to prove. And that's Baker versus Burlington Northern Inc., Idaho Supreme Court, 1978. On summary judgment, where the non-moving party bears the burden of proof at trial, the moving party need only prove that there is an absence of evidence to support the non-moving party's case. That's Nursing Home Pension Fund, Local 144 versus Oracle Corporation, 9th Circuit 2010, which itself cites Celotex Corp. From the Supreme Court. And see also Federal Rule of Civil Procedure 56, Advisory Committee's notes to 2010 amendments, which recognize that a party who does not have the trial burden of production may rely on a showing that a party who does have the trial burden cannot produce admissible evidence to carry its burden as to the fact. Summary judgment should be entered after adequate time for discovery and upon motion against a party who fails to make a showing sufficient to establish the existence of an element essential to that party's case and on which that party will bear the burden of proof at trial. And that's Celotex Corp. And so after adequate time for discovery, well, discovery's closed. So I think by definition, there has been adequate time for discovery, especially since, She was granted an additional 5 months to respond to some of that discovery. And Rule 56, remember we looked at it last time we looked at summary judgment. You can bring a summary judgment motion at any time. It can be your opening salvo. You can instead of bringing an answer or a motion to dismiss, you can bring a motion for summary judgment right out of the gates as a defendant. You obviously can't bring a motion for summary judgment in lieu of a complaint, because without a complaint, there is no lawsuit. But the defense, right out the gates, their opening volley can be the summary judgment motion. Now, generally, there's not going to be enough information for the summary judgment. That's why you're generally going to want at least some discovery. No facts support Ms. Guillard's statements that Professor Scofield had any role in the murders of the 4 students, or that Professor Scofield was involved in any personal relationship with KG. In her responses to Professor Scofield's requests for admission, Ms. Guillard purported to deny the requests, asking her to admit she had no factual support for her statements about Professor Scofield. However, the detail of her responses demonstrate that she has no such facts. She repeatedly stated that discovery is still pending. Public information from the victim's social media may show that the plaintiff met the murdered students. Ms. Guillard responded similarly when asked to admit she knew of no physical evidence linking Professor Scofield to the murders, or that she was not aware of any physical evidence showing Professor Scofield had an affair with KG. She stated, "I deny this matter. There's plenty of evidence to be discovered during the civil discovery process or criminal trial. Discovery is now closed." Ms. Guillard has no evidence that proves any aspect of her statements about Professor Scofield. They are false. Even Ms. Guillard's subpoena ducis tecum to the University of Idaho uncovered no evidence supporting her statements. And a subpoena ducis tecum, while it sounds kind of dirty, it's a subpoena for documents, a subpoena for a thing, as opposed to a subpoena to appear, which I can't remember the Latin off the top of my head for that kind of subpoena. But either way, a subpoena ducis tecum is, give us this thing. Generally, you can't get a gag order. I'm not closely following the Rudy Giuliani defamation. But in that case, it might actually be good policy, just because with Rudy Giuliani's reach, with his following, getting an injunction might be good policy, just because his continued chattering really is putting his victims in actual physical danger. And so generally it's not good policy. But once again, there's at some point, it might actually be harassment. It might actually be criminal. So generally, prior restraint isn't allowed. But if your actions are putting people in danger, it might be. And once again, in this case, they've already won. So that doesn't mean you automatically get one. Generally, the remedy is bring another lawsuit, which apparently they have. But here in this case, Professor Scofield hasn't won yet. She should have won already, but she hasn't, so she doesn't even have that. But I'd have to read more to give you a more definitive answer, because generally the courts aren't going to do it, because generally it's going to be unconstitutional. But as with everything, there are exceptions. So they might get it. I don't know, but unless they already have in the Rudy Giuliani case, I don't know. It would just be speculation on my part. But like I said, because of his reach, because of actual threats made against them, they might have a better case. But I don't know. It's hard to say, because like, where is the line? Because in this case, the line is pretty far in one direction, in that you don't get the gag order, the injunction, whatever, in most of the cases. And it's just in the extreme cases that you might be able to. But once again, I don't know exactly where that line is. I've never practiced in that area, so it's hard to say. Or at least I'm not the one to determine where that line is. So that's where I am. The University of Idaho responded that it had no communications between Professor Scofield and any of the murdered students. The University of Idaho also had no record of the students ever being enrolled in a class taught by Professor Scofield. Professor Scofield's statements in her declaration are undisputed. Professor Scofield did not know any of the murdered students, did not have an affair with KG, was not in Moscow when the murders occurred, and was not involved in the murders. That's from her declaration. That's sworn testimony. It is evidence. Professor Scofield's undisputed declaration proves that Ms. Guillard's defamatory statements that Professor Scofield was involved in or orchestrated the students' murders or had an affair with one of the victims were false. Ms. Guillard's responses to Professor Scofield's requests for admission that her statements were based on a tarot card reading, which she believes also do not give rise to a genuine dispute of material fact. At best, the tarot card readings are inadmissible hearsay, an out-of-court statement offered for the truth of the matter asserted. That's Federal Rule of Evidence, Rule 801A. I think it was in the last live talking about the Janet, where we looked at the Federal Rules of Evidence, specifically 801A. And well, I mean, we looked at more than just that, but we looked at a lot of the hearsay rules, like what's exception to hearsays, what's not considered hearsay that you'd think is hearsay. There's lots of fun stuff. Moreover, Ms. Guillard has no personal knowledge of the facts she divined from the tarot card reading. She states only that she believes the reading. This is not sufficient evidence to create a genuine dispute of material fact on the affirmative defense of truth, for which she, Ashley Guillard, carries the burden of proof. As this court has stated when it dismissed Ms. Guillard's counterclaims on August 8th, 2023, Based solely on her claimed ability to psychically divine the truth, defendant makes extraordinary allegations about how plaintiff orchestrated the murder of 4 people to cover up a secret romantic relationship with one of the victims. These claims are not only conclusory and unverifiable, but arguably so outrageous as to be clearly baseless and thus implausible. Ms. Giard still has no verifiable or admissible facts to support her extraordinary and false allegations that Professor Scofield orchestrated the murder of 4 people to cover up a secret romantic relationship with one of the victims. There is no genuine dispute of material facts, and summary judgment as to liability is proper. Conclusion. For the reasons stated herein, Professor Scofield respectfully requests that the court grant plaintiff's motion for partial summary judgment and hold Ms. Giard liable for her defamatory statements as a matter of law. The evidence conclusively, not conclusorily, but conclusively establishes that Ms. Giard's statements defamed Professor Scofield. All that remains is for a jury to determine the amount of Professor Scofield's damages. Dated January 12th, 2024, by Stoll Reeves, signed Wendy J. Olson and her other attorneys. And it was served on Ashley Giard via ECF and email. And that's the end of that. And I mentioned there is the plaintiff's amended statement of undisputed material facts. I don't think I'm going to go through that because it's been 2 hours and almost 42 minutes. And I think I'm done. I don't think I can get through 10 pages of undisputed material facts, especially considering, well, those are, we've already covered them. We've already seen all the citations to them, and so we don't actually need to see them. And how did I get it, Miss Dinner? I think I need dinner soon too, because everyone else already ate, I'm sure. And so where are we? We've got all these exhibits. We don't need to do those. Let's see if we don't know what the leave to file document is yet. We may do a video on that soon, but not tonight. Surrender monkey, if you cause a mistrial, I mean, Law Talk with Mike might not agree, but you do need pants in court. It's required, unless, of course, skirts are fine too, but generally, I mean, a kilt is formal, so probably could wear a kilt to court, although a tuxedo actually isn't appropriate in court, and the kilt and full regalia kilt is appropriate at black tie, so a tuxedo. So it might actually be too dressy for court, but down with pants, off with legs. Well, at least I did, because sitting here for 3 hours without moving, the brim of my socket digs into my nether regions and gets uncomfortable. So I do these streams generally in my pajamas with my leg in the other room. But yeah, so I don't know what my next video is going to be. Like I said, before I was reminded, once again, thank you, Paul Berry. Before I was reminded that this was posted today, I was going to do the Las Vegas courtroom attack. I'm still going to do that, but it might not be the next video. We'll see. I need to try to get a hold of CC Suarez again because I really want to cover that, the other Janet controversies, her takedown requests of CC Suarez video. But she hasn't responded to my email, but I might have emailed her wrong email address. So yeah, I want to do that though. So either way. But for those of you who were here for the girlies stuff, that the Braun versus Day that we talked about for a minute in the beginning, if I knew how, I would redirect you to the Friday Night Frenzy over on Law and Lumber, because I don't know exactly what they're talking about today, but it appeared, on the thumbnail, it had the husband of one of Janet's clients, the Bunny XO's husband, Jelly Roll. So I don't know if it's related to Janet or if it's just Jelly Roll litigation they're talking about. But if I knew how to redirect you, I would redirect you to Law and Lumber. Instead, I'm just saying they started 48 minutes ago, so go over there and watch Friday Night Frenzy. And thanks for joining me. I will see you soon. Do all the YouTube-y things here too first. Like, share, subscribe, bribe your friends and family to do the same. And I will see you soon. Bye-bye.